Thank you for joining Mayer Brown's Global Receivables and Supply Chain Finance webinar today. This is the fifth in a series of 9 webinars that will run through to November to keep our clients up to date on developments and noteworthy issues in the supply chain finance market. In today's seminar, we will be discussing the use of drafts and bills of exchange in supply chain finance. My name is Thain. I'm a partner in the firm's Banking and Finance department in London, and one of my responsibilities here at Mayer Brown is to help to look after our supply chain finance in the UK. As part of that, I cover a number of products such as asset-based lending, receivables finance, payables finance, and trade finance. I'm today joined by Angie, Chia, and Massimo Capretta. Angie is a partner in our Singapore office and has more than 20 years of experience in trade finance. Angie has spent considerable time both in-house and at private law firms and is widely recognised as one of the leading trade finance lawyers in Asia. Massimo is a partner in our Chicago and New York offices. Massimo has spent his entire career focusing on different aspects of accounts receivable and accounts payable financing, from securitization to asset-based lending to supply chain finance. He is well known to most of the larger finance providers in the New York market, and each year he and his team advise on many of the largest and most sophisticated supply chain finance facilities in the US market. We have a number of counterparts around the firm, and if you've been dialing into this series, you will have already heard from some of them. Our team here at Mayer Brown is currently made up of over 50 professionals spread across Europe, Asia, and the Americas, and we're very proud to be a trusted advisor to a number of the world's leading market participants. If you are a client of Mayer Brown, you probably know that for several years now, our supply chain finance team has hosted a series of live events in New York, London, Hong Kong, and Singapore to discuss current events and developments in the supply chain finance market. And in 2019, over 600 guests attended these programs. Unfortunately, we had to postpone those events this year because of the current health situation, but we hope that we'll be able to get together again next year. In the meantime, we hope you'll find our webinar series useful, and a description of the remaining programs in the series is contained at the end of this slide deck. Before we begin, I'd like to cover a few administrative matters. First, at the bottom of your screen, you will notice there are multiple buttons you can use. Answers to some common technical issues are located in the Help section. Also, in the resource list is a PDF of today's slide deck. This webinar is being recorded, and in a day or so, we'll be sending you an email with a link which you can use to listen to the webinar again or share with your colleagues. The recording will also be posted on our website. Finally, we do plan to allow time during the seminar for questions. To submit a question electronically, please use the Q&A button. If we don't get to your question during this seminar, we will make every attempt to follow up with you afterwards. With that done, let's get started. We thought that we would start by looking at the legal framework in which bills of exchange operate internationally. Bills of exchange are used every day to facilitate cross-border payments within trade transactions. And you would expect there to be a recognised international law for an instrument that has been used for hundreds of years. But in fact, there isn't. Broadly speaking, international bills of exchange law is based on 2 distinct legal systems, resulting in broadly 4 approaches to how bills of exchange are dealt with across the world. The first legal system is the common law system, and countries which broadly follow the English Bills of Exchange Act. This applies to the UK, the US, Hong Kong, Singapore, almost all the Commonwealth countries and other countries which originally founded their legal system on the common law. Those countries might not necessarily have followed the English Bills of Exchange Act exactly, but generally their local statutes follow the same principles set out in the Bills of Exchange Act. The second legal system is the Geneva Convention system. This is based on a set of rules agreed at the 1930 Geneva Convention, setting out laws for the unification of bills of exchange. This system was adopted by most countries of continental Europe, Russia, Japan, and Brazil, although a number of those jurisdictions codified those rules in their own civil codes with various amendments. As such, broadly speaking, we have those countries operating on a form of the English common law, those countries operating on the rules set out in the Geneva Convention, or their own laws based on the form of the Geneva Convention, those countries operating on completely their own set of laws, and then finally those countries which have no laws dealing with bills of exchange at all. It's worth also mentioning that in 1966, the United Nations set up a committee called the United Nations Committee on International Trade Law, otherwise known as UNCITRAL, with the purpose of studying the problem of harmonization of the laws relating to international trade. And after 2 decades, in 1988, the United Nations published and adopted the Convention on International Bills of Exchange and International Promissory Notes. But although certain countries are signatories to this convention, including the US, no country has yet implemented the convention. We've included this map in the slide deck so that you can see how the various legal systems are generally spread across the world. And that's before you consider what type of bills of exchange laws they are applying. So hopefully that has helped to set the scene and give you a feel for the general legal framework in which bills of exchange operate. And later in the seminar, we will briefly look at how to determine which laws take precedence when you have a conflict between 2 different legal regimes. But I'll now hand over to Massimo to look at what is a bill of exchange.
Thank you, Charles. So very quickly, just to go over this slide, and just to highlight at the beginning, the reason Charles did the slide before was just to highlight that, of course, there are different systems, and these instruments will look slightly differently in every jurisdiction. So if what you're seeing on the screen isn't familiar to you, then that's okay, right? But generally speaking, overall, there are some very common rules, and of course, what makes a bill of exchange is that essentially it's an unconditional instrument or order in writing, addressed by one person to another, signed by the person giving it, and it requires the person to whom it's addressed to pay on demand or at a fixed or specific time in the future or a determinable time in the future a sum of money that is either fixed or determinable on the face of the instrument to a specific person to order, so, i.e. to the person who the original payee assigns it to, or to bearer. And the point of it is that it is an independent payment obligation that exists in and of itself and is embodied in the instrument itself. So it doesn't represent something that is owed, so it isn't like a credit agreement where it just describes a debt. It is the debt, and it lives on its own. And is, as Charles was saying a slide or two ago, it is created by statute almost always, and exists, within the statutory framework of any particular country. And then, of course, I always try to mention this because I think it really confuses people, at least locally here in the U.S. So bills of exchange don't actually technically exist under U.S. law. We'll get to it a little bit later, but under U.S. law, what governs a bill of exchange or what creates that instrument is Article 3 of the Uniform Commercial Code. And under Article 3, the instrument that we're discussing in this slide presentation or this webinar is what is referred to as a draft, or, if it's transferable, a negotiable draft. So a lot of times on U.S. transactions, you'll hear about drafts or draft purchase agreements. We're talking about the same thing. It's just a different set of terminology.
Thank you, Massimo. So now we know what a bill of exchange or draft looks like and the characteristics for a document to qualify as a bill of exchange as laid down by legislation. Let's delve a little deeper into the technical terms that usually causes a lot of confusion. And we do emphasize that this is technical, as we are interpreting the Bills of Exchange Act 1882. Yes, you heard that right, 1882. Although it has been amended from time to time, the Act originally dates back almost 140 years, as does the case law interpreting this Act and the other statutes that follow the 1882 Act. Please note that this discussion is based on the formal Bill of Exchange based on the English Bill of Exchange Act, as this is what we most commonly see across our desks. We get asked, and we ask several questions when we deal with negotiable instruments. Why a bill of exchange, not a promissory note? Well, bills of exchange, promissory notes, and checks usually come under the same legislation and have broadly similar characteristics. But the key difference between bills of exchange and promissory notes is that bills of exchange more clearly caters for three different roles, whereas promissory notes are bilateral. Checks are, of course, now used pretty much exclusively by banks. Looking at the slide, in a normal trade flow, the seller will draw the bill of exchange. The bill of exchange will be addressed to the buyer as a drawee. The bill of exchange is accepted by the buyer, signifying its obligation to pay the amount set out on the face of the bill of exchange. So where does the finance provider come in? Under the legislation, the bill of exchange can be drawn payable to the drawer or to the order of the drawer, or the named payee, or less commonly, payable to the drawee or to the order of the drawee. The finance provider is usually a payee or an endorsee, where the seller drawer endorses the bill of exchange to the finance provider, where the bill of exchange is made to the order of the drawer seller. The legislation sets out the form of the bill of exchange, how parties must be identified, including how it's addressed. What is a sum certain? In other words, a sum that is determinable. The legislation deals with concepts of interest, installments, rates of exchange. The legislation dictates how the form of acceptance would look like, where it must be written, how it must be written, when a bill of exchange may be accepted, how the acceptance must be completed by delivery or notification. What exactly does delivery mean, and when it can be presumed? The legislation dictates capacity of the parties, issues around signature, and we will address signatures in greater detail later on in the webinar. The legislation will also decide when a bill of exchange is negotiable or transferable, what is a valid endorsement, and what are the rights of the holder. Okay, so we have established that the Bill of Exchange Act is very prescriptive. And in order to fall within the ambit of the Act, we have to fulfill the requirements as prescribed in the Act that was drafted over 140 years ago and against the backdrop of cases over the last century. So finance providers who have dealt with bills of exchange and drafts always want to be a holder in due course. So what does that mean, and is that important? The Bill of Exchange Act defines a holder as the payee or the endorsee who is in possession of the Bill of Exchange, or the bearer. So the finance provider may be a holder in one of these three ways. So what rights does a holder have? Under the UK Bill of Exchange Act, the rights of the holder are that he may sue on the bill in his own name. But where he is a holder in due course, he holds the bill free from any defect of title or prior parties, as well as from mere personal defenses available to prior parties amongst themselves, and may enforce payment against all parties liable on the bill. Where a party's title is defective, if that party negotiates a bill to a holder in due course, that holder obtains good and complete title to the bill. And if he obtains payment on the bill, the party that pays him gets valid discharge of the bill. Under Section 54 of the Act, the acceptor of the bill is precluded from denying from it in favor of the holder in due course from the existence of the drawer, the genuineness of the drawer's signature, capacity, authority, and there are other benefits. There are other sections in the Act which differentiate the position of a holder in due course as against other types of holders. So we know that the legislation accords to the holder in due course certain protections, more protections than other types of holders. So the next question you would ask is, how does a finance provider become a holder in due course? The Act will also legislate what is a holder in due course. And in substance, a holder in due course is someone who takes the bill in good faith and for value. And at the time the bill was negotiated to him, he had no notice of any defect in the title of the person who negotiated it in his favor. So what amounts to a defect in title? Title is defective if at the time he obtains the bill or the acceptance of the bill, there is fraud, duress, or force and fear, or other unlawful means, or an illegal consideration, or when he negotiated it in breach of faith, or under circumstances as amount to a fraud. Quite a number of things that we have to consider. On top of that, the Act does provide certain presumptions. So every party who signs the bill is presumed to have provided value, and every holder of the bill is prima facie deemed to be a holder in due course. But if in an action on a bill it is admitted or proved that the acceptance, issue, or subsequent negotiation of the bill is affected by fraud, duress, or force and fear, or illegality, the burden shifts. So, coming under the Bill of Exchange Act as a holder in due course is not a miracle cure. There are some benefits, but the Act just gives you a presumption that can be rebutted. Now, we also have to bear in mind the case law in different countries. And in the Hong Kong case of Antwerp Diamond, Bank N.V. and Paymaster, the court actually decided that there was a lacuna, a gap in the Bills of Exchange Act or the Bills of Exchange Ordinance as it is known in Hong Kong. And what that case decided was that under common law, the payee, which is a holder for value of a bill, that took the bill under the conditions which fulfilled Section 29, which is the holder in due course section, although he could not claim to be a holder in due course, his position was elevated and he could have the same rights as a holder in due course vis-a-vis a remote party, such as an acceptor, and was not liable to be defeated either by defects of title or by any personal defense which the acceptor might set up against drawer. It was only where the instrument was not complete and regular on the face of it, or there were other circumstances to put him on inquiry, that any defect in title within the meaning of the Act would defeat him. So whilst we know that there is legislation, whilst we know that there are gaps in this legislation, there may be case law in certain jurisdictions that may change your status depending on whether you're a payee, holder for value, or a holder in recourse, or a holder in possession. There are definitely many things to consider.
Thanks, Angie. I think before we move on, we thought it'd be good if we just included a little bit of a sidelight on holder in due course in the United States, because there are a couple of specific issues that exist under U.S. law that you probably aren't going to find most other places. And also, they tend to be issues that are particular to, finance providers or banks especially, which we thought we'd hit on. First of all, as I mentioned earlier in the presentation, in the United States, there is no Bill of Exchange Act the law around bills of exchange or drafts is found in Article 3 of the Uniform Commercial Code, and which is the same law that controls also under Article 9 security interests and liens, also sales of open accounts, and Article 2 provides the basic contracting law in the United States between commercial parties. So I think one of the particularities of the U.S. system is that the law around bills of exchange is very closely connected to those other bits, right? They're in theory supposed to work harmoniously together, but sometimes it isn't necessarily the case. So of course, in Article 9, which governs both liens and the sale of accounts receivable, there is a mirroring provision to the holder in due course test in Article 3, which basically says, of course, that you can be a holder in due course and that you can take interests free of prior claims. The test for holder in due course itself, which is also on this slide, very similar to English law, same kind of concepts. But the couple of things to keep in mind when you're dealing with U.S. law is one, of course, our law is much more modern than in England. The basic law that forms, the Article 3 was created in 1896, which was, at least a decade after England. So we were almost to the 20th century. So because of that, and kind of in line with that, of course, the test for holder in due course, and as you can see on the slide, contains the references to the same two sort of big elements that Angie was talking about, which is good faith, no notice, right? And good faith in the U.S. is not really covered in the code. I mean, those are principles that are based on many years of case law, but the same thing with notice. But the important things to remember in the U.S. are, one, that there actually, even though we call it the Uniform Commercial Code, there are actually two versions of Article 3 that exist in the U.S. There is the New York version, which is an older version of Article 3, and then there is the version of Article 3 that was adopted in the 1990s and subsequently adopted by all of the other states in the United States, which is oftentimes referred to as the more modern version. And those two different versions of Article 3 address these two issues, good faith, notice, slightly differently, and oftentimes come to different results. So, for example, obviously in the United States, most people know there's a filing system or a personal property lien recording system, that many people who do secured loans or do purchases of receivables are familiar with, because, those types of interests need to be recorded in order to actually be effective. And the way that these two principles are dealt with in light of that system will vary depending on where you are in the U.S. So, for example, do you have an affirmative duty to actually investigate or search those systems in order to determine or satisfy yourself that there are no conflicting claims, or can you rely purely on the assertions of the party selling you the instrument? Oftentimes, or at least in literature, depending on where you are in the U.S., you might come to a different conclusion to, problem that exists kind of aligned with this, but that is particular to large financial institutions, is the notice issue, right? Because I don't think there's any real question in the U.S. or any dispute about the fact that if you are the trade finance department of a large global bank and you are purchasing instruments from a company, entity, supplier, seller, whatever, and then, there's someone somewhere else in the bank, maybe down the hall or in another group or in another segment or in another country, that has direct knowledge that that transaction isn't permitted or is subject to encumbrances. Under U.S. law, you would be bound by that knowledge whether or not you had it yourself. And it's sort of issues like that that tend to really complicate this holder in due course analysis. And kind of highlighting what Angie was saying, but even more here, these are highly fact-specific determinations. And it's one of the reasons that I think people pay a lot of attention to this kind of stuff here in the U.S. because, whether or not you are a holder in due course is ultimately going to be decided by a court somewhere someday. And it is not, it's not an open and shut kind of determination. It's that court is going to look at a lot of specific facts and circumstances that are particular to the transaction that you're engaging in. So that's one of the reasons why it's very difficult for us. I know it's difficult for my colleagues around the world, but it's especially difficult for us in the U.S. to actually tell someone on any particular transaction and given any set of facts whether you are or are not going to be a holder in due course, because there's so many variables that it becomes very difficult to actually make a conclusion in advance. And I think I've belabored that to death, so we're going to move on. But we did want to have that discussion because, for us here, it tends to be one of our most focused on kind of issues in these types of instruments.
So we thought we'd take a few moments now to discuss conflicts of laws in respect of bills of exchange. And as I mentioned earlier, there are various legal regimes across the globe dealing with bills of exchange. And as already mentioned, bills of exchange are commonly used to facilitate payments cross-border. But which laws are applicable to a bill of exchange, noting that in particular that a bill does not express on its face what law governs it, and a bill is essentially comprised of a number of different contracts between the various parties. For example, are the laws of the jurisdiction where the bill is drawn applicable? What about the laws of where the bill is accepted? What laws govern an endorsement? And what laws govern whether the person signing it actually had capacity to do so? As you might have guessed, a single law would not be applicable to all those questions unless the bill has no foreign element at all. Further, there is actually scope for multiple laws being applicable to the same aspect of the bill because there's no harmonization internationally as to which laws should apply or take precedence for each aspect. As such, when dealing with bills of exchange cross-border, it's important to understand which laws might be applicable and ensure that you're complying with those laws. Let's look at this first from an English conflict of law perspective. So what law governs a person's capacity to sign a bill of exchange or endorsement? Well, for individuals, i.e. not corporates, the position under English law isn't actually that clear. And it could be any of the laws of where that person is domiciled, the law of where the contract takes place, or the proper law of the bill. For corporates, though, which is what we tend to deal with more often, it's generally accepted to be the laws of where the corporate is incorporated. Next, what laws govern the form of the bill of exchange, i.e. what are the requirements for what makes the instrument a bill of exchange, and some of the things that Massimo was discussing earlier. In this case, English law says that the form will be governed by the laws from where the bill is issued, which is typically the place where the bill is drawn. Similarly, the laws governing the form of an endorsement are the laws where the endorsement is made. Next, and probably one of the most important, is what laws govern the effect, interpretation and validity of an acceptance or an endorsement, i.e. the payment obligation that arises under the acceptance or the endorsement. And English law says that this is the laws of where such acceptance or endorsement is actually made. So let's put that into an example. If a bill is drawn by a company in England, accepted by a company in Singapore, and endorsed by the English company to a US company, English law says that It'll be English law that governs the requirements for the form of the bill, because it was drawn in England. Singapore law will govern the effect, interpretation, and validity of the payment obligation by the Singaporean acceptor, because it was accepted in Singapore. English law will govern the effect, interpretation, and validity of the payment obligation by the English endorser, because it was endorsed in England. And then the capacity of each company to sign the relevant parts of the bill will be governed by their own local laws. So as you can see, it's not that straightforward when dealing with cross-border bills. And that assumes that the Singapore and US conflicts of laws, which are the other jurisdictions involved in that example, that their conflict of law analysis follow the same approach. So thinking about that, Angie, would you be able to comment on how the Singaporean laws would look at that type of scenario?
Well, this is one of the benefits of being part of the whole English law regime, and both Singapore and Hong Kong as former colonies of England, we adopted the English Bills of Exchange Act 1882 pretty much verbatim. So there is consistency between all three jurisdictions. And so we would have less issues in terms of conflicts of laws, because the relevant provisions within our Act would also look at conflicts of laws similarly to English law. But Massimo, I'm sure US will have something different.
You love saying that, don't you?
I do.
Well, I think I'm going to make you happy here, Angie, because I think maybe the thing to say about the U.S. is that, I think at least philosophically, broadly speaking, I think the U.S. would follow a lot of those same principles. But there are a couple of particular issues here that are worth noting. One is that, as I've been saying in previous slides, that Article 3 is part of the UCC, but there are a couple of things to remember if you're not based in the U.S. One is that the Article 3 does not, in and of itself, have any of its own choice of law rules. And the second thing to kind of remember, I think, is that as a general principle, the Uniform Commercial Code is not the best on choice of law issues. Mostly because there are no clear choice of law issues. It's actually one of the real weaknesses of the code overall. And part of that is intentional and part of it is not. But what we do tell people when dealing with transactions where there's a U.S. connection is that you should not, or you should at least assume or take into account the fact that no matter what the law is or might be, even in the treatises, there is a long tradition in the United States of ignoring that and just applying U.S. law anyway. And that you could view that different ways, either because you could say that that it's part of the American psyche of always thinking we know how to do things better. It could be because U.S. law courts tend to be not as familiar with these types of instruments as other places in the world, but or it could be that that's just how we do things here. But I think we always try to caution people. There's sort of an academic answer, which I think you would find is very much in line or very close to or very similar to what the approach would be under the English system. But then there's sort of the practical answer that, of course, there's much less deference here to foreign law than there is in a lot of other places. So we would always advise people to make sure that whatever transaction they're doing, it is compliant with the U.S. system if it has a U.S. connection. And I think that's one of the reasons why in the U.S. you tend to find much less willingness on the part of banks especially or finance providers to purchase or discount bills of exchange in and of themselves, purely based on the instrument. I think you tend to find, it is the case in other places in the world, you tend to find here that it's almost the vast majority of the time, the finance provider is going to want a contractual framework behind that bill to kind of establish some of those rules that there may not be certainty of on the bill in and of itself. So yes, Angie, you're correct. It's not the same, and I'm sorry. But let's move to the next slide. Okay, so we're going to move on to the next slide, and we want to talk a little bit about how bills of exchange are signed and accepted, because there are actually a lot of differences about that around the world. And broadly speaking, sort of big picture, I mean, essentially there are three methods that you tend to see. And, of course, historically and originally, and, if you follow the words of most of these acts, what they have in mind is, essentially wet ink signature and a physical instrument that gets passed around, among parties. And that's been the case for, many, many, many years, and goes back, I understand, as far back as the Middle Ages. Essentially, you sign the instrument, and it gets delivered to the ultimate purchaser or discounter of the instrument, and they hold it, and everything's well. Of course, that's incredibly time-consuming. So, the second major model you tend to see are, execution through powers of attorney, in which case, some entity, generally a bank, right, or some sort of finance provider, receives a power of attorney from one or both of the parties on the bill, granting them the right to, sign, accept, endorse, depending on whatever role it is, on behalf of that party. That's, in most places around the world, an accepted method of doing this, and you see that a fair amount. On that item, the one item that we'll just mention, or I'll mention, and the reason that it's not, the best panacea out there all the time is that, of course, powers of attorney, as Charles and Angie were discussing a little bit earlier, the same types of local law rules apply to, the entity signing the bill in the first place. So essentially, if you want a power of attorney from a company in country X, of course, you're going to have to make sure that that's a valid way of getting a power or getting authority in that country. You need to make sure that the power of attorney that you get signed is compliant with local law, so that it's actually enforceable and, recognizable against that entity if and when the time comes. So, it sounds great, but, not all of the time is that going to be a very straightforward process if you're dealing, in a multi-jurisdictional type of transaction or structure. And then, of course, the third, wide, broad category of signing is e-signature. And Charles, I know you've spent a lot of time focusing on this, so and why don't you talk about that now, and when Angie and I'll chime in at the end.
Yeah, no problem. And just to say, the position under English law with regard to wet ink signatures and the use of power of attorneys are broadly the same as what you've just described. But as you said, with regard to electronic signatures, more recently we're seeing, at least in the UK market, participants looking at whether bills of exchange can be signed electronically. And to be clear here, what we're talking about is we're not talking about electronic bills of exchange, i.e. Bills of exchange which exist purely in the electronic form. What we're talking about is creating a bill in electronic format, applying signatures of the bill electronically, and then printing it to create the bill and delivering the bill in the usual way. And based on the English Bills of Exchange Act, English common law principles for execution of documents, and the various statutes and regulations on electronic signing of documents, there doesn't appear to us to be any reason why a bill of exchange cannot necessarily be signed electronically. But equally, there's limited, if any, authority that definitely confirms that. However, it does definitely raise a few interesting questions. For example, how do you necessarily distinguish between the bill which was printed with the intention of it being the original bill and, say, another copy of that bill which was printed out simply as a copy? How do you evidence that the bill delivered to the holder was the original and not the copy? It seems to us that if operating on the basis of electronic signatures, that probably the relevant parties should support that arrangement with some sort of additional contractual protections to mitigate some of those concerns and questions. And so the bill, the intention of a bill of exchange sort of acting in isolation, some of the benefits of that perhaps goes away when you have to start putting a contractual framework around it to mitigate some of those questions. And Angie, have you seen anything similar in Singapore?
Fortunately, the acts in Singapore and Hong Kong are a little bit clearer. So under the Electronic Transactions Act, bills of exchange are specifically excluded. So you cannot, come within and deal with bills of exchange electronically, both signing it or dealing with it electronically. And Massimo, to your point, powers of attorney under the Singapore Electronic Transactions Act are also excluded. So you're right that you have to make sure that you're very, very clear in terms of jurisdiction you're dealing with and whether or not you can sign documents electronically if they are excluded from the Electronic Transactions Act that's in Singapore. In Hong Kong, similarly, negotiable instruments are also outside of the ambit of the Electronic Transactions Ordinance. So you can't use electronic records or electronic signatures when you're dealing with negotiable instruments in Hong Kong. So for us, it's pretty clear. It's just out of scope. Massimo, any thoughts?
Yeah, well, unfortunately, it's actually pretty similar here in the U.S., Angie. But here it's kind of a two-part issue. So first, Article 3, which governs negotiable instruments, it doesn't actually contain any provision for electronic signature. Now, there's been a lot of activity in the U.S. I think there's a clear market accepted desire to have some sort of national provision to allow for electronic signature of drafts. But the thing about Article 3, of course, is that it's a law, that's state law that exists in each of the 50 states. So even though I think there's a good movement afoot to actually make those changes, that it'll take a very long time here for that to happen, because the new provisions would need to be agreed upon and then implemented in every state. That's a very multi-year, often maybe even a decade process. So the other approach that is being considered here in the U.S. is to change the e-signature laws themselves, which in the United States exist on a federal level in most states, because there's a federal law. And I think, essentially to circumvent the UCC restrictions and to, say that you could have electronic signature of negotiable instruments. I think it looked like there was some possibility that would actually happen relatively near term, but it hasn't. It seems to have sort of ground a little bit to a halt or a little bit been on pause. So right now, I think we're still in the same position as you are in Hong Kong and Singapore. I mean, the law is fairly clear that isn't permitted, and there just is no real provision for that under U.S. law. And I think that's one of the reasons you're seeing people, especially with COVID, trying to grapple with how to actually do this, and especially on some of the larger sort of supply chain programs that use these types of instruments. And we've seen people kind of taking a lot of different approaches. For example, a lot of banks or other entities that issue that have those types of programs, they're trying to, deal with it through indemnities or some sort of, other way to try to get some protection, because the actual act of physical signing just isn't possible. But broadly, we're kind of in the same place you are, Angie, and I think it's still going to be a little bit of time before this is a reality in the U.S.
Interesting.
Charles, you have anything? Or I think if we talk this to death.
Yeah, I think we're good on that one.
Okay, well, let's move on then.
Okay, so we have looked at the technicalities in the Bill of Exchange, the complexities around the conflicts of laws, hopefully demystified the position of the holder in due course. And now we come to the most important part. How does one monetize a Bill of Exchange? In the 1977 House of Lords decision in the case of Nova Jersey Knit Limited and Camden Spinnery GmbH, Lord Wilberforce said, "When one person buys goods from another, it is often, one would think generally, important for the seller to be sure of his price. He may have bought the goods from someone else whom he has to pay. He may demand payment in cash, but if the buyer cannot provide this at once, he may agree to take bills of exchange payable at a future date. These are taken as equivalent to deferred installments of cash. Unless they are to be treated as unconditionally payable instruments, which seller can negotiate for cash, the seller might just as well give credit. And it is for this reason that English law does not allow cross-claims or defenses, except such limited defenses as those based on fraud, invalidity, or failure of consideration." So, this bill of exchange, this asset, which is as good as a deferred installment in cash, against which limited defenses can be raised, can be transferred or negotiated from one person to another. In the realm of traditional trade products, forfeiting has been around for decades. And in 2013, the ICC published the Uniform Rules of Forfeiting, or URF 800. This contains a set of rules for the conduct of primary and secondary markets, including the examination of documents and the liabilities of parties when they deal with bills of exchanges and other transferable instruments. The other set of rules relevant to bills of exchange are the Uniform Rules of Collection, or URC 522. In current times, the banks sometimes offer a seller-led receivables purchase only after they have handled documents under URC 522 to, amongst other things, mitigate the risk of fraud. What I would like to emphasize is that URC 522 is not a magic bullet that will cure the due diligence in respect of the conflicts of laws. I would like to draw your attention to Article 8 of URC 522, where the responsibility lies with the remitting bank to instruct the collecting bank and to provide the form and wording for the creation of the bill of exchange. Otherwise, the collecting bank shall not be liable or responsible for the form and the wording of any bill of exchange. And as we've already covered earlier, the conflicts of law in respect of the form of the bill of exchange may not necessarily follow the position of, let's say, the Bills of Exchange Act, as such acts do not have extraterritorial effect. Under Article 22 of URC 522, the responsibility lies with the presenting bank to ensure that the form of acceptance of a bill of exchange is complete and correct, but not the genuineness of any signature or authority of the signatory. This ties into the type of holder the finance provider is, but remember that this only if the finance provider is a holder in due course, it only raises presumption in favor of the finance provider. So, where do recent developments take us?
Thank you, Angie. I think we'll take just a minute, and I think now that we've discussed some of the more traditional uses, we want to mention, since this is a supply chain presentation, of course, over the last, decade or so, the big use of these types of instruments has been for, what we call on the screen large-scale payables platforms. But essentially, we know that, and we know some of the people who do this around the call. But, for some market participants, and especially some of the larger banks, have adopted this model as the primary product or vehicle by which they offer, payables-based supply chain products. And, there's definitely pluses and minuses to these types facilities and over, the alternative, which is usually open accounts receivables purchase. And some of the pros are relatively obvious if you think about it. One is that, it's going to definitely avoid, or at least to some extent lessen, some local law issues that exist with open account programs. I know that a lot of people who use these, they sort of reach the conclusion that by having a negotiable instrument based facility, it's much easier to collect against the ultimate buyer, who is the real customer, especially if that ultimate buyer is in a place like the United States or in England, and they don't have to worry as much about some of the local law, sort of perfection, existing claims, that kind of stuff. Another, kind of benefit of these types of programs is that, they're based on an existing framework of law that is well understood in a lot of places that may be more familiar with those types of instruments than, a straight open account purchase, which isn't as common in some parts of the world. There's definitely some real negatives with these types of programs too. The first one is that because of the issues we discussed at the beginning, they essentially always require, or almost always require, the generation of a lot of paper. So there's a lot of, administrative work that doesn't exist for regular transactions. And on the large scale ones, that's essentially going to involve somebody sitting in a back office somewhere generating a lot of paper, and making sure that it's kept and that it's signed properly and, all that kind of stuff. And of course, that also doesn't negate, and because of some of the things we were talking about before, some of the, sort of power of attorney, authorization type issues that are still going to exist, even if some of the sort of perfection type issues may go away. And I'm not sure there's a whole lot more to say about that other than to say that there are pluses and minuses, and they're going to be equally, some people are going to weigh this one way, and some people are going to look at open account as more workable. And I don't think there's really a great answer to that either way. But Charles, do you have any thoughts before we move on?
Yeah, just one extra one is that, some of these programs, from an accountancy perspective, a bill due by a debtor sometimes can look better than an IPU in terms of whether there's a characterization of whether that's debt or not. So that potentially that's another pro for these type of programs.
Yeah, actually, just a minute, and to go off script a little bit, I think you said something really critical. I think if we ever get to a system where these instruments are actually e-signable, and especially if we can get to, an electronic instrument, which I know you're going to talk about in a minute, I think that's going to be the way these types of structures go, and we're really going to see much less IPU type structures, because I think they tend to create a lot of difficulty that doesn't exist with these types of instruments. But to foreshadow the future, let's move on and talk about some things that aren't what we have in place today.
Thanks, Massimo. So looking into the crystal ball into the future, UNCITRAL has tried to do something about electronic transferable records. When it first came out with the Electronic Transactions Model Law, Electronic Contracts, and Electronic Signatures Model Law, it knew the complexities with transferable documents. So there was actually a specific intention to deal with transferable documents at a later stage, and finally it did so after the successes that it had under the Electronic Contracts and Electronic Transactions and Electronic Signature Model Laws. However, the conflict of laws is a very difficult beast to tackle. And the purpose of the model law, and they did specifically say that, right, in the model law of electronic transferable records aims to enable the legal use of electronic transferable records both domestically and across borders. And it defines transferable documents or instruments typically to include bills of lading, bills of exchange, promissory notes, and warehouse receipts. Under Chapter 4, which deals with cross-border recognition of electronic transferable records, Article 19 specifically says that an electronic transferable record shall not be denied legal effect, validity, or enforceability on the sole ground that it was issued or used abroad. But it also provides that nothing in this law affects the application to electronic transferable records of the rules of private international law governing a transferable document or instrument. So UNCITRAL tried, but it still doesn't address the conflicts of laws. And the model law in its explanatory note actually says it does not aim to affect in any manner existing law applicable to transferable documents or instruments, which is referred to as substantive law and includes rules on private international law. And what does substantive law include? Substantive law includes the negotiability as part of a local law issue. So whilst UNCITRAL's model law on electronic transferable records does provide some benefits, it is not going to be the cure-all for each and every aspect that we will see in bills of exchange as transferable documents. What UNCITRAL is trying to ensure is that it accommodates developing technology and expresses the same concept of data integrity that we saw in the model law for electronic contracts and signatures. It is a good idea, but as pointed out earlier, it does not cure the issues with regards to conflicts of law and certain substantive law issues. Additionally, the question is how long it will take for the model law to be ratified across the globe. The model law was adopted in July 2017. As at September 2020, the model law has been adopted in one country, Bahrain. As a basis of comparison, the UNCITRAL model law on electronic commerce was adopted in 1996. An additional article was adopted in 1998. But as at 2020, there are 74 countries that have adopted the model law. So Charles, what else does the future hold for us?
So putting aside UNCITRAL's model law on the basis that it hasn't been adopted in a lot of countries, unfortunately the bills of exchange regimes in most jurisdictions do not support the concept of a digital bill of exchange. And this is different to what we were talking about earlier in terms of electronic signatures. This is now having a bill of exchange which exists purely digitally or electronically. And the reason being is, for example, the English Bills of Exchange Act requires a bill to be delivered in order for it to be effective. And delivery is defined as the transfer of possession. And this creates an issue under English law, as the prevailing view is that it's not possible to transfer possession of something which is intangible, which is how a digital bill would be characterized, because it does not physically exist, but instead exists electronically. But is it possible to create something akin to an electronic bill of exchange that sits outside of the bills of exchange regime? In order to do so, the instrument would need to be something which is an irrevocable and unconditional payment obligation with no defences to payments, so some of the stuff that Massimo was talking about earlier, and payable to a holder in due course. It needs to exist in an immutable electronic form controlled by the holder, so in a form which is electronic and then once created can't be amended, and it needs to be freely transferable by the holder. So in terms of creating an electronic record or something that is immutable and freely transferable, the technology for this already exists. We have distributed ledger technology such as blockchain, and that can assist in that respect, and it's already used for other types of crypto assets. In terms of creating an irrevocable and unconditional payment obligation with no defences to payment, and which can be transferred, well, again, that can be achieved using contracts. between the parties and using an assignment as the mechanism for transfer. And we already see that type of payment undertaking in payables finance programs. And so coupling distributed ledger technology together with an IPU, you can create an electronic irrevocable payment undertaking akin to a bill of exchange. And this is what ITFA, the International Trade and Forfeiting Association, has been working on for a number of years. And they recently produced their manual for digital negotiable instruments, containing an example English law governed electronic payment undertaking. So is this the future for bills of exchange if the legislation is not amended to accommodate electronic bills of exchange? Well, it's hard to say. Like, clearly an instrument created under contract as opposed to being a creation of statute would likely have more vulnerabilities to challenge, notwithstanding any waivers or defences. And similarly, with the transfer of the instrument being conducted through an assignment rather than under an operation of statute, this potentially creates another avenue for challenge. Further, to date, this has only been created for English law, and its use outside England would require due diligence in any of the jurisdictions which are relevant. So as always, time will tell with something like this. And, you know, there's other industry bodies like BAF which have also been trying to produce similar type of arrangements. So on that bombshell, that wraps up the main part of today's seminar. We hope that you found it useful. Unfortunately, it looks like we've run out of time for questions, but as mentioned at the start, please do ensure you submit any questions you'd like, and we will try and respond to you over the next couple of days. So on behalf of Mayor Brown and my colleagues, thank you for your time today. I hope you found this seminar useful, and we hope you can join us for future programs listed on the back of the slide deck, and invites will be sent out in due course. Just some final housekeeping items. A recording and link to the materials from this seminar will be distributed to you by email in the next day or two, and please do watch your inbox for invitations to our future seminars. Thank you again for attending today.